Hindu far-right groups in the US are trying to defend India's Discriminatory Citizenship Amendment Act, or CAA, by projecting it as some sort of a progressive law through false equivalencies and misinformation. In this video, let's debunk one of their new claims that falsely equates the CAA with the American Lautenberg Amendment. Here are the facts. Indian law does not recognize refugees, not even under the CAA. India only has ad hoc refugee policies. It has no refugee law. In the US, on the other hand, the Immigration and Nationality Act lays down detailed asylum-seeking and refugee determination processes. The US is also a state that is party to the Refugee Convention, while India is not. Indian law, including the CAA, does not mention refugees or persecution as a standard for determining refugee status. In the absence of the fundamental legal recognition of people seeking refuge, no law in India can be compared to the US Lautenberg Amendment because the former does not recognize refugees, while the latter is made specifically for refugees. The second difference is that because Indian law does not recognize refugees, this law does not require that an individual be fleeing persecution in order to qualify for fast-track citizenship. The Lautenberg Amendment specifically functions under a refugee admissions category and is limited only to those who wish to join their families in the United States. They have to meet the fear of persecution standard, albeit under a reduced burden of evidence. By contrast, the CAA is a complement to the National Register of Citizens, or NRC, an official listing of all Indian citizens. International human rights groups have warned that the CAA-NRC combination aims to strip millions of their citizenship, and for Muslims there would be no way to regain that citizenship in a fast-track manner, exactly the kind of policy you would expect from a government trying to turn India into a Hindu ethno-state. The long story short is, the CAA is about dismantling human rights, not preserving them.